Hi there. So now we will be discussing Rule 112. So study sesh ulit, and we'll start by reading the Kodal. So Rule 112, Preliminary Investigation. Section 1, Preliminary Investigation defined. When required, preliminary investigation is an inquiry or proceeding to determine whether there is sufficient ground to engender a well-founded belief that a crime has been committed and the respondent is probably guilty thereof and should be held for trial. Except as provided in Section 7 of this rule, a preliminary investigation is required to be conducted before the filing of a complaint or information for an offense where the penalty prescribed by law is at least 4 years, 2 months, and 1 day without regard to the fine. Section 2. Officers authorized to conduct preliminary investigations. The following may conduct preliminary investigations: provincial or city prosecutors and their assistants, national and regional state prosecutors, other officers as may be authorized by law. Their authority to conduct preliminary investigations shall include all crimes cognizable by the proper court in their respective territorial jurisdictions. Section 3. Procedure. The preliminary investigation shall be conducted in the following manner. The complaint shall state the address of the respondent and shall be accompanied by the affidavits of the complainant and his witnesses, as well as other supporting documents to establish probable cause. They shall be in such number of copies as there are respondents, plus 2 copies for the official file. The affidavits shall be subscribed and sworn to before any prosecutor or government official authorized to administer oath, or, in their absence or unavailability, before a notary public, each of whom must certify that he personally examined the affiants and that he is satisfied that they voluntarily executed and understood their affidavits. Within 10 days after the filing of the complaint, the investigating officer shall either dismiss it if he finds no grounds to continue with the investigation, or issue a subpoena to the respondent, attaching to it a copy of the complaint and its supporting affidavits and documents. The respondent shall have the right to examine the evidence submitted by the complainant, which he may not have been furnished, and to copy them at his expense. If the evidence is voluminous, the complainant may be required to specify those which he intends to present against the respondent, and these shall be made available for examination or copying by the respondent at his expense. Objects as evidence need not be furnished a party but shall be made available for examination, copying, or photographing at the expense of the requesting party. Within 10 days from receipt of the subpoena, with the complaint and supporting affidavits and documents, the respondent shall submit his counter affidavit and that of his witnesses and other supporting documents relied upon for his defense. The counter affidavits shall be subscribed and sworn to and certified as provided in the first paragraph of this section, paragraph A, with copies thereof furnished by him to the complainant. The respondent shall not be allowed to file a motion to dismiss in lieu of a counter affidavit. If the respondent cannot be subpoenaed, or if subpoenaed does not submit counter affidavits within the 10-day period, the investigating officer shall resolve the complaint based on the evidence presented by the complainant. The investigating officer may set a hearing if there are facts and issues to be clarified from a party or a witness. The parties can be present at the hearing but without the right to examine or cross-examine. They may, however, submit to the investigating officer questions which may be asked to the party or witness concerned. The hearing shall be held within 10 days from submission of the counter affidavits and other documents or from the expiration of the period for their submission. It shall be terminated within 5 days. Within 10 days after the investigation, the investigating officer shall determine whether or not there is a sufficient ground to hold the respondent for trial. Section 4. Resolution of investigating prosecutor and its review. If the investigating prosecutor finds cause to hold the respondent for trial, he shall prepare the resolution and information. He shall certify under oath in the information that he, or as shown by the record, an authorized officer, has personally examined the complainant and his witnesses, that there is a reasonable ground to believe that a crime has been committed and that the accused is probably guilty thereof, that the accused was informed of the complaint and of the evidence submitted against him, and that he was given an opportunity to submit controverting evidence. Otherwise, he shall recommend the dismissal of the complaint. Within 5 days from his resolution, he shall forward the record of the case to the provincial or city prosecutor or chief state prosecutor or to the ombudsman or his deputy in cases of offenses cognizable by the Sandigan Bayan in the exercise of its original jurisdiction. They shall act on the resolution within 10 days from their receipt thereof and shall immediately inform the parties of such action. No complaint or information may be filed or dismissed by an investigating prosecutor without the prior written authority or approval of the provincial or city prosecutor or chief state prosecutor or the ombudsman or his deputy. Where the investigating prosecutor recommends the dismissal of the complaint, but his recommendation is disapproved by the provincial or city prosecutor or chief state prosecutor or the ombudsman or his deputy on the ground that a probable cause exists, the latter may, by himself, file the information against the respondent or direct another assistant prosecutor or state prosecutor to do so without conducting another preliminary investigation. If upon petition by a proper party under such rules as the Department of Justice may prescribe or motu proprio, the Secretary of Justice reverses or modifies the resolution of the provincial or city prosecutor or chief state prosecutor, he shall direct the prosecutor concerned either to file the corresponding information without conducting another preliminary investigation, or to dismiss or move for dismissal of the complaint or information with notice to the parties. The same rule shall apply in preliminary investigations conducted by the officers of the Office of the Ombudsman. Section 5. When warrant of arrest may issue. By the Regional Trial Court, within 10 days from the filing of the complaint or information, the judge shall personally evaluate the resolution of the prosecutor and its supporting evidence. He may immediately dismiss the case if the evidence on record clearly fails to establish probable cause. If he finds probable cause, he shall issue a warrant of arrest or a commitment order if the accused has already been arrested pursuant to a warrant issued by the judge who conducted the preliminary investigation, or when the complaint or information was filed pursuant to Section 6 of this rule. In case of doubt on the existence of probable cause, the judge may order the prosecutor to present additional evidence within 5 days from notice, and the issue must be resolved by the court within 30 days from the filing of the complaint or information. If by the municipal trial court, that's when required pursuant to the second paragraph of section 1 of this rule, the preliminary investigation of cases falling under the original jurisdiction of the Metropolitan Trial Court, Municipal Trial Court in cities, Municipal Trial Court, or Municipal Circuit Trial Court shall be conducted by the prosecutor. The procedure for the issuance of a warrant of arrest by the judge shall be governed by paragraph A of this section. When warrant of arrest not necessary, a warrant of arrest shall not issue if the accused is already under detention pursuant to a warrant issued by the municipal trial court in accordance with paragraph B of this section, or if the complaint or information was filed pursuant to section 6 of this rule, or is for an offense penalized by fine only. The court shall then proceed in the exercise of its original jurisdiction. Section 6. When accused lawfully arrested without warrant. When a person is lawfully arrested without a warrant involving an offense which requires a preliminary investigation, the complaint or information may be filed by a prosecutor without need of such investigation, provided an inquest has been conducted in accordance with existing rules. In the absence or unavailability of an inquest prosecutor, the complaint may be filed by the offended party or a peace officer directly with the proper court on the basis of the affidavit of the offended party or arresting officer or person. Before the complaint or information is filed, the person arrested may ask for preliminary investigation in accordance with this rule, but he must sign a waiver of the provisions of Article 125 of the Revised Penal Code as amended in the presence of his counsel. Notwithstanding the waiver, he may apply for bail, and the investigation must be terminated within 15 days from its inception. After the filing of the complaint or information in the court without a preliminary investigation, the accused may, within 5 days from the time he learns of its filing, ask for a preliminary investigation with the same right to adduce evidence in his defense as provided in this rule. Section 7. Records. Records supporting the information or complaint. An information or complaint filed in the court shall be supported by the affidavits and counter-affidavits of the parties and their witnesses, together with the other supporting evidence and the resolution on the case. Record of preliminary investigation. The record of preliminary investigation conducted by a prosecutor or other officers as may be authorized by law shall not form part of the record of the case. However, the court, on its own initiative or on motion of any party, may order the production of the record or any of its part when necessary in the resolution of the case or any incident therein, or when it is to be introduced as an evidence in the case by the requesting party. Section 8. Cases not requiring a preliminary investigation nor covered by the rule on summary procedure. If filed with the prosecutor, if the complaint is filed directly with the prosecutor involving an offense punishable by imprisonment of less than 4 years, 2 months, and 1 day, the procedure outlined in Section 3A of this rule shall be observed. The prosecutor shall act on the complaint based on the affidavits and other supporting documents submitted by the complainant within 10 days from its filing. If filed with the municipal trial court, if the complaint or information is filed with the municipal trial court or municipal circuit trial court for an offense covered by this section, The procedure in Section 3A of this rule shall be observed. If within 10 days after the filing of the complaint or information, the judge finds no probable cause after personally evaluating the evidence or after personally examining in writing and under oath the complainant and his witnesses in the form of searching questions and answers, he shall dismiss the same. He may, however, require the submission of additional evidence within 10 days from notice to determine further the existence of probable cause. If the judge still finds no probable cause despite the additional evidence, he shall, within 10 days from its submission or expiration of said period, dismiss the case. When he finds probable cause, he shall issue a warrant of arrest or a commitment order if the accused had already been arrested, and hold him for trial. However, if the judge is satisfied that there is no necessity for placing the accused under custody, he may issue summons instead of a warrant of arrest. So, that's it for Codal for Rule 112. And then I'll just take a break and then we will resume with the discussions. Alright, so hindi lahat ng topics sa Rule 112 kasama sa Bar Syllabus. So, I won't be discussing everything. So, yung nandito lang sa Bar Syllabus is authorized officers, determination of probable cause, cases not requiring preliminary investigation, motion to reopen, motion for reinvestigation, modes of review, inquest proceedings. Yun lang. Pero, feeling ko mas marami pang akong madidiscuss eh. Kesa sa yung what is covered. So, yan. Anyway, I won't be defining preliminary investigation already. Yun, nag-codal naman na tayo. Because it's not covered. So, what, since here, cases not requiring preliminary investigation, okay, let's discuss what doesn't require preliminary investigation and what requires. So, preliminary investigation is required before the filing of a complaint or information for an offense where the penalty prescribed by law is at least 4 years, 2 months, and 1 day without regard to fine. Therefore, not requiring is yung baliktad nito. If the offense is if the offense involves a penalty that prescribes if the offense prescribes a penalty of imprisonment of 4 years, 2 months and below. Yun yung not requiring. And yun yung kailangan ng PI. Yung tungkol sa chartered cities naman kasi, it's not a PI if it's a chartered city or if it requires preliminary investigation, then you're required to file it with the Office of the Prosecutor. But it's for purposes of institution of criminal action where you institute it. So, exception, there's no right of preliminary investigation in Rule 112, Section 6, when a person is lawfully arrested without a warrant. However, a person arrested shall be subject to inquest proceedings. So, yun yung exception. Again, yung hindi nagre-require ng preliminary investigation if the prescribed penalty is 4 years and 2 months and below. And if lawful yung warrantless arrest. However, subject to inquest proceedings. Okay. I think it's also important to discuss that even if there is no preliminary investigation, it may be demanded by the accused. So if a person is arrested, he can ask for a preliminary investigation before the filing of complaint or information. But he must sign a waiver in accordance to Article 125, kaya nga dun sa Codal. So, Article 125 of the RPC, ano ba yan? delay in the delivery of detained persons to proper judicial authorities. Okay. So, kailangan kasi kapag dapat yung authorities hindi mag-delay in delivering such persons sa proper judicial authorities. But, if kailangan ng preliminary investigation, then there will be delay. So, pinapasign yung accused ng waiver para hindi nga i-demanda because there will be a delay because nag-request siya ng preliminary investigation. And after the filing of the information or complaint, the accused may within 5 days from the time he learns of its filing ask for preliminary investigation. This is if he is not in custody or he was not arrested. So, okay na yan. The right to preliminary investigation is not waived if failure to appear before the prosecutor during the clarificatory hearing or when summoned when the right was invoked at the start of the proceeding, when the accused filed an application for bail and was arraigned over his objection and the accused demand that preliminary investigation be conducted. So, punta naman tayo sa authorized officers. I'm gonna go dun sa mga nasa Bar Syllabus lang muna na topics. Yun yung una ko i-discuss. And then, if hindi pa ako pagod, we can discuss the other concepts under Rule 112. So, if in case na you're a student taking up CRIMPRO, so that this video can also help you. So, officers authorized to conduct a preliminary investigation, persons authorized to conduct, provincial or city prosecutors and their assistants, national and regional state prosecutors, and such other officers as may be authorized by law, such as the COMELEC, Ombudsman, and PCGG. Their authority to conduct preliminary investigation shall include all crimes cognizable by the proper court in their respective territorial jurisdiction. So, let's also discuss the authority of the Ombudsman. The power of the Ombudsman to make investigation extends to any legal act or omission of any public official, whether or not the same is committed in relation to his office. This, however, does not include administrative cases of court personnel because the 1987 Constitution exclusively vests in the Supreme Court administrative supervision over all courts and court personnel. It is not the function of the office of the Ombudsman to rule on the guilt or innocence of the accused. Its function is to weigh the evidence presented together with the counter-allegations of the accused and determine if there was enough reason to believe that a crime has been committed and that the accused is probably guilty thereof. So, parang prosecutor pa din siya pero sandigin by a specialized prosecutor. So, authority of the PCGG. The PCGG has the power to investigate and prosecute such ill-gotten wealth cases of former President Marcos, his relatives and associates, and the graft and corrupt practices cases that may be assigned by the President to the PCGG to be filed with the Sandigan Bayan. For COMELEC, the COMELEC and other prosecuting arms of the government, such as the DOJ, now exercise concurrent jurisdiction in the investigation and prosecution of election offenses. Instead of a mere delegated authority, the prosecuting arms of the government, such as the DOJ, ayun, inulit lang. So, that's another, motion to reopen, motion for reinvestigation. So where an information was filed or a warrant of arrest issued pursuant to an irregular preliminary investigation, the accused may file a motion for reinvestigation. But once the complaint or information is filed in court, any motion for reinvestigation is addressed to the sound discretion of the court. A motion for reinvestigation is a prohibited motion if the motion is filed without prior leave of court, when preliminary investigation is not required under Section 8 Rule 112, and when the regular preliminary investigation is required and has been accurately conducted, and the grounds relied upon in the motion are not meritorious, such as issues of credibility, admissibility of evidence, innocence of the accused, or lack of due process, when the accused was actually notified, among others. So prohibited motions shall be denied outright before the scheduled arraignment without need of comment and or opposition. So let's search this DOJ Department Circular 27 series of 2022. Tignan natin sa DOJ website. Sabi dito, resolutions of the provincial or city prosecutors in cases cognizable by the MTCs shall be reviewed on appeal by the regional prosecutors. In the case of NCR, by the Prosecutor General. I'm trying to find the mismong hirap naman hanapin ito. Can't seem to find it. Pero basically yun. Pwedeng i-review. Can't find the law itself. This is so frustrating. Anyway, yun na yun. Hanapin nyo na lang. If mahanap nyo, comment down below. Because I also need it. Can't seem to find it. The last topic is inquest. So an inquest is a formal and summary investigation conducted by an inquest prosecutor in cases where a person has been arrested without a warrant for an offense requiring preliminary investigation, and made for the purpose of determining whether the warrantless arrest was valid and determine whether there is probable cause to file information. So, na-discuss na natin yung 125, diba? Yung delay. So, waiver nun. In the absence or unavailability of an inquest prosecutor, the complaint may be filed with the offended party or peace officer directly with the proper court on the basis of affidavit of the offended party or the arresting officer or person. So, that's an inquest. So, yun lang yung sa Bar Syllabus. I will just rest for a bit and then we will discuss the entirety of Rule 112 because we're extra like that. But if you're after the bar lang na review for Rule 112, you can skip to the part where we will discuss bar cues relating to Rule 112. Okay, so preliminary investigation. Again, it's an inquiry or proceeding to determine whether there is sufficient ground to engender a well-founded belief that a crime has been committed and the respondent is probably guilty thereof and should be held for trial. Koda lang din. So, inquisitorial lang ang preliminary investigation. And it is often the only means of discovering the persons who may be reasonably charged with a crime to enable the prosecutor to prepare his complaint or information. And sometimes kasi yung mga tao mag-file ng complaint, wala namang crime, diba? Or parang wala namang basis or hindi naman tama. So, bakit pa mag-aaksaya ang gobyerno ng pera, ng resources para sa isang sham case or sham allegation or sham accusation? That's why fina-file mo na sa prosecutor. Ito yung parang unang filter na by basis ba talaga? Tama ba talaga? Hindi pwedeng mag-file lang kahit anong reklamo dyan sa court kasi you would be wasting the time of the court. Ang dami-daming kaso dyan, hindi lahat na-accommodate. So, kung worthless lang din naman, diba? Hindi dapat makalusot yan sa prosecutor. So, dapat may solid na reason why you're filing a case and may possibility of actually winning. There should be a case talaga. There is a case. Of course, hindi ba lalaman yan until a full-blown trial is pero the prosecutor also has to believe himself after examination that there is a case here and that a crime has probably been committed indeed, diba? So, yun. Who determines probable cause? This is an executive function that the courts cannot interfere with in the absence of grave abuse of discretion. So, yung prosecutor. A prosecutor cannot then be compelled by mandamus to file a case against an alleged criminal except when such prosecutor acted with grave abuse of discretion amounting to lack or excess of jurisdiction. So, the prosecutor has the power to exercise discretion if this is worth pursuing, if the case is worth pursuing. Pwede kang mag-file ng mandamus, napilitin mo si prosecutor mag-file ng case kasi the private complainant cannot. Basta criminal case. Civil case, sure. Pero criminal case, it's people of the Philippines, dapat i-accept muna ni prosecutor, siya yung magpa-file ng kaso. Gagawa niya ng information yan. Yung complaint. Tapos yung offended party, witness na lang yan of the state. So, absent this grave abuse of discretion amounting to lack or excess of jurisdiction, hindi pwedeng i-compel si prosecutor. Nasa discretion niya. Pwedeng mali yung exercise ng discretion niya, pero hindi deliberate and conscientiously made. Diba? Statutory base of the right to preliminary investigation. This is not a constitutional right. The right thereto is of statutory character and may be invoked only when specifically created by statute. It is not a fundamental right and may be waived expressly or by silence. So the right to preliminary investigation again is a personal right which the accused may waive. Pwedeng hindi na siya magpa-PI. Pero advantageous kasi kay accused na magpa-PI siya kasi pag piniayan ni prosec tapos may possibility kasi na hindi na i-file sa court kasi doon pa lang sa prosecutor level wala na eh, parang ganon. So yun, however pwedeng i-waive ni accused kasi it's just a statutory right, but pwedeng nga i-waive expressly or impliedly, but it has to be unequivocal, clear na winave niya, even if implied. Mere failure of a defendant and or his counsel to appear during PI cannot be construed as a waiver. Okay, so continuing, when right deemed waived, expressed waiver or by silence, failure to invoke it during arraignment, consenting to be arraigned and entering a plea of not guilty without invoking the right of preliminary investigation. When right not deemed waived, failure to appear before the prosecutor during the clarificatory hearing or when summoned when the right was invoked at the start of the proceeding, when the accused filed an application for bail and was arraigned over his objection and the accused demanded that preliminary investigation be conducted. So what's the purpose of preliminary investigation? Again, to inquire concerning the commission of the crime and the connection of the accused with it. This is so that the accused may be informed of the nature and character of the crime charged against him, and if there is a probable cause for believing him guilty, that the state may take the necessary steps to bring him to trial, and to preserve the evidence and keep the witnesses within the control of the state, and to determine the amount of bail if the offense is bailable. So, na-discuss na natin who may conduct the determination of existence of probable cause. So, what is probable cause? Pertains to the facts and circumstances sufficient to support a well-founded belief that the crime has been committed and that the accused is probably guilty thereof. So, the quantum of evidence now required in preliminary investigation is such evidence sufficient to engender a well-founded belief as to the fact of the commission of a crime and the respondent's probable guilt thereof. So, mababa lang siya. A preliminary investigation is not the occasion for the full and exhaustive display of the parties' evidence. So, prosecutor must ensure the existence of prima facie case and a reasonable certainty of conviction based on available documents, witnesses, real evidences, real evidence, and the like. Prima facie evidence is such status of evidence which on its own and if left uncontroverted is sufficient to establish all the elements of a crime. Hearsay evidence is admissible during preliminary investigation. So as to who may conduct, we already discussed it earlier. Kasi kasama sa Bar Syllabus yung who may conduct. Okay, ano pa yung mga hindi natin napag-usapan? Procedure. Yung procedure of preliminary investigation kasi hindi kasama sa Bar Syllabus eh. So, filing of the complaint, that's the first step. So, the complaint shall state the address of the respondent. Kasi kailangan aware si respondent ng case filed against him. Shall be accompanied by the affidavits of the complainant, yung nagre-reklamo, and his witnesses, if meron, and other supporting documents to establish probable cause. Just remember Consti, I also made videos sa Consti, the right of the accused to be informed of the accusation against him. So yon, the affidavit shall be subscribed and sworn to before any prosecutor or government official authorized to administer oath, or if absent or unavailable, then a notary public. Punta ka lang sa notary public for the purpose of this ha. If walang available na government official or prosecutor, each of whom must certify that he personally examined the affiants and that he is satisfied and that they voluntarily executed and understood their affidavits. And copies of such complaint will be furnished to the respondents plus 2 copies for the official file. So, kung ilan yung respondents, dapat may copies sila each. So, caudal. So, punta na lang kayo sa first part of the video. Action of the investigating officer within 10 days after the filing of the complaint. Again, 10 days. The investigating officer shall. So, assess niya yan, diba? So, kung walang ground to continue the investigation, i-dismiss na yung complaint. Meaning, hindi siya magpa-file ng kaso. Pero pag meron naman yung gagawin niya, mag-issue siya ng subpoena to the respondent. And i-attach niya dyan yung complaint and all supporting documents and affidavits na sinubmit ni complainant. Then respondent has the right to examine it and the evidence submitted by the complainant. Tapos, pwede niyang ipa-recopy at his expense. And then, di ba, may 10 days. May 10 days si investigating officer from the filing of the complaint to either to decide to dismiss or to issue a subpoena. Pero pagka-issue ng subpoena doesn't mean na magfa-file agad si prosec ng kaso. Ipapaalam niya dun kay respondent, tapos si respondent would have the chance to file his counter affidavit. So it must be made within 10 days from the receipt of that subpoena with the complaint and yung subpoena and complaint na pinadala sa kanya. So from that receipt, meron siyang 10 days, calendar days to. And then the respondent is not allowed to file a motion to dismiss in lieu of the counter affidavit kasi wala pa namang kaso eh. Kailangan niya lang mag-reply dun sa prosecutor. Kailangan niya i-convince si prosecutor na this case is not worth pursuing kasi there's no case. Parang ganon. If the respondent cannot be subpoenaed or if subpoena does not submit counter affidavits within the 10-day period, the investigating officer shall resolve the complaint based on the evidence presented by the complainant. Hindi ibig sabihin na hindi nag-reply si respondent, matutuloy na yung kaso. Kailangan pa rin i-assess ni prosecutor based sa sinubmit ni complainant, diba? Kasi hindi nag-submit si respondent eh. Kung nag-submit sana si respondent, mako-compare niya, diba? Mas full picture yung makukuha niya. Pero pag si respondent, hindi nga ginawa to, hindi siya nag-submit, then yung magiging basis lang ni prosecutor for making the decision whether to pursue the case or not would be what was submitted by the complainant. So, it's also possible that there will be a clarificatory hearing. The investigating officer may set a hearing if there are facts and issues to be clarified from a party or witness. The parties can be present at the hearing, but without the right to examine or cross-examine. Again, this is not a trial. Parang patawag lang ni prosecutor para ma-clarify siya sa talagang nangyari or ma-verify yung certain facts. So, no examination or cross-examination. The investigating prosecutor, however, can ask questions, of course. The parties, however, may submit to the investigating officer questions that they want to ask the party because they can't directly ask questions. They can't cross-examine each other. But they can ask doon sa kabila. They can send in questions to the prosecutor and the prosecutor may ask if needed ng clarifications. And that hearing shall be held within 10 days from the submission of the counter affidavits of yung last na ano. So, kung may counter affidavit si respondent, then ayun, from the expiration of their submission. And yung clarificatory hearing na to, 5-day period lang to. It must be resolved within 5 days. So, pwedeng shorter than 5 days, basta maximum 5 days. And within 10 days after the investigation, the investigating officer shall determine whether or not there is sufficient ground to hold the respondent for trial. So, not receiving a copy of affidavits of a co-respondent does not deny a respondent his right to due process, since the rules of procedure require that the respondent be furnished a copy of the complainant's affidavit and other supporting documents. So, resolution of the investigating prosecutor. No case shall be filed with the first level courts if there is no reasonable certainty of conviction for the same. There is a reasonable certainty of conviction when a prima facie case exists based on evidence at hand, including but not limited to witnesses, documentary evidence, real evidence, and the like. Kasi nga trabaho ni prosecutor na i-determine if it's a case worth pursuing, if talagang napakawalang kwenta, there's no reasonable certainty for conviction of the same. Why the hell do we need to go to court? Diba? Kasi, yun na nga, yung sinasabi ko nga, it's taxpayer money. It's dagdag clogging of the court. So, it should be actually worth it. So, it gives pressure. This is by virtue of the DOJ circular just issued last February 2023, last year. It's a reminder sa prosecutors to do their job and huwag hayaan makalusot yung mga walang kwentang cases. So, ayun. Dapat sufficient to establish all elements of the crime or offense. So, kung may parang kulang, wag na dapat palusutin. Dun pa lang sa prosecutor level. Prosecutors must ensure the existence of a prima facie case and a reasonable certainty of conviction based on available documents, witnesses, real evidence, and the like. Prima facie evidence is such status of evidence which on its own and if left uncontroverted is sufficient to establish all elements of a crime. Maski elements lang naman ng crime. Diba? Appeal to Secretary of Justice. The resolution of the Chief State Prosecutor, Regional State Prosecutor, and Provincial City Prosecutors may be appealed before the Secretary of Justice within 15 days from receipt of resolution or of denial of the motion for reconsideration, reinvestigation. Pero dun nga sa pag-usapan natin yung nasa Bar Syllabus, diba? Pwede nang i-review ng mas higher na prosecutor yung mga ginawa ng lower na prosecutor. Unless the Secretary of Justice directs otherwise, the appeal shall not hold the filing of the corresponding information in court on the basis of the finding of probable cause and the appealed resolution. The appellant and trial prosecutor shall see to it that pending resolution of the appeal, the proceedings in court are held in abeyance. As a general rule, all petitions for review of resolutions of provincial city prosecutors in cases cognizable by the MTC, METC, MCTC shall be filed with the regional state prosecutor. So the Secretary of Justice may also review resolutions. Okay. If the complaint is filed outside NCR and is cognizable by the MTCs, METCs, MCTCs, the ruling of the office of the prosecutor may be appealable by way of petition for review before the regional prosecutor, state prosecutor, which ruling shall be with finality. If the complaint is filed with NCR and cognizable by NDC, may be appealable by way of petition for the Prosecutor General. If the complaint is filed within NCR and not cognizable with MTC, METC, MCTC, appealable with okay, basta yun. So, remedies to review the resolution of the investigating officer, file an appeal with an investigating officer, parang MR sa kanya rin. The appeal does not prevent the filing of the corresponding information in court based on the finding of probable cause in the appealed resolution, unless the Secretary of Justice directs otherwise. So, pwede din petition for review to the Secretary of Justice. So, yun. That's it. Tignan nga natin ulit tong hindi ko mahanap. Yung DOJ circular na to. Naiinis ako na hindi ko mahanap yung buong law. I'm just getting like a sort of summary. Basta resolutions of provincial city prosecutors cognizable by MTC, MCTC shall be reviewed on appeal by the regional prosecutor or prosecutor general sa NCR. So, this hindi ka dediretso sa Secretary of Justice. So, pwede mo siyang i-appeal muna sa regional para hindi siguro mapuno din doon si Secretary of Justice na sa kanya binabato lahat directly. Kumbaga dinagdagan ng additional step dun sa hierarchy ng appeal. Yun. I guess that's everything for Rule 112, and then I will take another break and then we will discuss bar Qs regarding preliminary investigation. Okay, so bar Qs tayo. Pipiliin ko na yung mga bar Qs. Kasi yung iba parang jurisdiction na discuss na natin eh. Or parang i-summarize ko na lang. Basta most dito, yung problem is, kung warrantless arrest ba, okay lang na walang PI. Sagot, okay lang. Inquest kasing kailangan dyan. Ang daming tanong pa ulit lang na ganyan. Tapos, ano pa? Meron dito, ang case daw ng RA 3019, tapos filed before the Sandigan Bayan against district engineer ng DPWH at private contractor. So namatay daw yung district engineer. Okay. Pwede pa rin ba dun sa ombudsman? So pwede, 'di ba? Kasi parang jurisdiction na yung Sandigan Bayan, may jurisdiction din sa mga ganon kasi in conspiracy sila. So pwede kasi private person basta in conspiracy with public officer. Despite na mamatay na yung public officer, magsasubsist pa rin to sa private. Ang dami na rin problem sa ganyan na discuss rin natin sa jurisdiction to. So since si ombudsman siya yung prosecutor sa Sandigan Bayan, then yes, magsasubsist. Ano pa? Yun, mga ganon. Ulit, inquest. Mostly ganun lang naman eh. At saka pwede kang mag-request, kapag na-inquest ka, pwede kang mag-request ng PI. So, yun. Okay na tayo sa 112. Sorry kung hindi ko na inisa-isa yung bar Qs kasi gusto ko pang magka-energy para gumawa ng video for 113. Basta yun lang naman yung mga paulit-ulit dito. Okay, thank you. See you.